May I
Yes,
start
yes.
the session, sir?
Start the session.
Sir, Department of Forensic Science of Maulana Abul Kalam Azad University of Technology, West Bengal, has organized this session on Introduction to Cyber Laws. And today, our eminent speaker, Advocate Vibhas Chatterjee, he is a special public prosecutor appointed by Government of West Bengal for the cyber law and electronic evidences. He is one of the renowned expert of digital forensic and cyber law in India. And now I may request to our Professor Arup Mukherjee sir for welcome speech. Then I may request to our Honorable Vice Chancellor sir for
Thank you, Mr. Mitra. Forensic science is a relatively new journey, but a successful step for the Macau WB. I welcome all the participants to take part in series of events that the department is organizing for the students as well as for the public. Forensic science has got very nascent stages in India, but through many discourses from many experts in different aspects, we are enlightening, or we are trying to give information, disseminate informations in forensic sciences areas. This is already become very, very important aspect in everyday life, modern life. Today, we are happy that we have one very renowned personality, and we gained in the department through his associations as well in forensic law, basically for cyber crime and cyber security. I welcome all participants for the seminar, for the webinar program, and I think I hand over to our Honorable Vice Chancellor, sir, for inaugural speech.
Sir, I may request to our Honorable Vice Chancellor, sir, for speak something for our participant and with us also.
Thank you very much. Good afternoon to all my panelists here. Sujoy Mitra, Gaurav Shrom, Professor Arup Mukherjee, Asmita Pal, and welcome to our resource person, Mr. Vibhas Chatterjee, and all the participants who have joined these digital platforms for attending this today's talk show on cyber laws. In recent past, we introduced these programs of cyber security and forensic science at our university. One is under Department of Information Technology, and another is as a full-fledged Department of Forensic Science. Now, when we introduced these two programs, we were apprehending that in near future there will be a huge demand of professionals in cybersecurity, in forensics and allied areas. Now, following our expectation, what we are seeing that a burgeoning growth or exponential growth in this field has happened and is being happening throughout the world. And in India, there are numbers of these institutes are coming forward following our examples to offer these sorts of programs, because we need a huge numbers of skilled professionals in these fields. And because this fields has a multi-dimensional essence, and it requires different sorts of legal framework and legal understanding of this legal formats for better handling these subjects, for better dealing the different evidence, different cases related to pertaining to all this cyber security and forensics. And we have seen that in recent times, everything is vulnerable. Most of them, everything needs the tight security. As far as the cyber space is concerned, we are seeing the cases of hacking from our this very important government departments, and that's why we are quite optimistic regarding the prospect of our program. And these programs we would like to enrich further, inviting many resource persons or from related fields, particularly from technical sides, from legal sides, and from the science sides, for the benefits of our learning community. Today, following our mandate, this program has been organized, and we are quite happy that an expert in this field, Mr. Bivas Chatterjee, he has kindly consented to remain present among ourselves for sharing his opinions, his expertise, his experiences with all our participants for enriching them. And this will be, I believe, a session of highest level of engagement. And the endeavor will continue. And I expect that all the participants who are present over here, they will be involving themselves in serious active learning, because from digital platforms, whatever is being deliberated and being shared, listening that and taking cue from that, you can always develop your own understanding, your own, notes and your own conception. And that's required for active learning, and that requires for serious for being seriously engaged in these sorts of learning exercises to gain the benefit of all these exercises. So all this with the involvement of our Department of Forestry Science under the leadership of Professor Arup Mukherjee, Sujay Mitra, and others, and with the deliberations of experts, Mr. Bivas Chatterjee, today's learners, they will have the opportunity to learn definitely some new things, and some new and they will have these experiences of understanding some new cases pertaining to this field of cyber laws. And I wish you all the best for this learning session. And again, my sincerest thanks to Department of Forensic Science, and particularly the research person today, Mr. Bivas Chatterjee, for being present today for the learning session of our cyber forensic and cyber security community. Thank you very much.
Thank you, sir, for your speech. We now I may request to our resource person, Advocate Bivas Chatterjee, to start his session.
Welcoming you, everyone. Today, we are in a very modern age forensic discussion. Now, the basic concept of forensic is that of bringing before the forum. So, basic meaning of the word forensic. And the forensic word is a very old one and been explored in many parts of the world throughout the time. But one of the father figure of this forensic is that Mr. Lockhart, which has been further interpreted by Mr. Kirk and all this. I'll come to those part. But basically, the most interesting line which has been given by to the interpretation of Lockhart exchange principle, Mr. Paul Kirk. I'll come to that as well. Now, basically, the cyber forensic, maybe unlike the other forensic, has got its peculiarities and specialties, and definitely the most important conception is that of it, how to handle electronic evidence, and electronic evidence being very sensitive one, and to handle it very sensitively and very cautiously has been recommended by the last 20-25 years judiciary in different judgments throughout the world. So bringing before the forum the truth, the real fact is a challenge. So basically, prior coming to my PowerPoint presentations and other, I just try to make out two important conception. I think basically it is the conception which will go with us in the long run. And one of the conception is that of you can call these both of them as a golden rule of cyber forensic. I can still remember in one of the economic offense case in Midnapur, that is a cheat fund case under PIT Fee Act. I have examined the assistant director of the Central Science Forensic Laboratory, and I have examined. I have a 5.5 page examination in chief on her, and try to build up the golden rule of cyber forensic with the help of that examinations. And even the cross examination was done by one of the renowned retired professors from Jadavpur University, to my witness, with the consent and the permission of the learned court, trial court. So we depend more on electronic records on that case, and after the Honorable Supreme Court's Gujarat judgment. Now, in the Gujarat judgment, Honorable Supreme Court says that a witness can be purchased. He can be influenced or win over, but electronic records sometimes are exclusive in nature. So we can rely more on electronic record than the even the truthfulness of a direct witness. So that's the fact, and that's the observation of Honorable Court. With that observation, I just start my class today. My observation discussion today. I'm a strong believer of electronic evidence coming up, and in doing so, electronic evidences are actually in a electronic device. So, say for example, this is my mobile phone. If this mobile phone is seized from me, today's investigating agency is more concerned not with the mobile phone itself, but more concerned with the data within it. So, in that perspective, the data within it, if we go and discuss on it, the data within it, we can understand that the data within it plays a very important role. And how we're going to take the data or collect the data or extract the data in a lawful way, so that that data can be easily presented before the court. Because in every electronic evidence handling or investigations and other, the three primary steps which we should all be careful about is that first is the collection of the electronic evidence, then the preservation of electronic evidence, and the third, presentation of electronic evidence before the court of law. So this digital evidence, now the electronic evidence, is actually in every investigation or trial or any fact-finding proceedings, the electronic evidence, it is not the electronic evidence which is important, it is how it is collected, how it is presented, and how it is preserved, and how it is presented before the court. And therefore a very important and interesting concept coming up. I think in your syllabus, I think this subject is there, and that is chain of custody. So the basic concept of a prosecution, the prosecutor has to prove a case beyond reasonable doubt, and his or her the chain of prosecution case should be such that there is no lacuna in any point of that chain with respect to the entire investigation or entire trial. So that is always there. And how going to deal with those electronic records or electronic documents, how those data can be extracted, and whether the chain of custody remains intact throughout the time of investigation till the trial is completed. So entire procedure actually to be looked into from the mind or the perspective of a forensic expert, because electronic evidence, many a judgment in different part of the world judiciary has clearly expressed that the electronic evidence is sensitive enough, and it can be easily tampered or destroyed or edited or it can be doctored. So in every case, the sensitiveness of dealing with electronic records is always a big issue, and those have to be, you have to be very careful. So in order to take guard of the entire electronic evidence preservations and keeping the integrity of the electronic records, we must keep in mind two very important golden rule. One is, no one is allowed to do anything with the original device or the primary device where the data was first time captured, and the another thing is that of the every step has to be documented. So in every cybercrime investigation or trial, the court has to look into these two fundamental golden rule of cyber forensic, that every step has to be documented, and this documentation ultimately go into making a proper chain of custody, and no one is authorized to do anything with the original device, because the time they're doing the original, because you know, in I'm a certified forensic expert from the Rochester University. So the first point we have been taught on the beginning of our subject is that MCA, that is whether the data was modified, it was accessed, or something is created. So if we got these three things, when the first time the offender was doing any crime and something was captured in the device which has been sent to the forensic expert, and if the forensic expert says that, okay, from the date of seizure of that device, the MCAs remain intact. So there is every possibility that the electronic evidence integrity was maintained. And obviously, you all know that we have MD5, we have SHA and others, which is actually in such a way algorithm that they can forensically image bit by bit image of, they'll make the bit by bit image of the entire data, and in doing so they are going to create a number we all know that's a hash value. So this hash value coming from a hash function is a one-way traffic, and you know, the concept resembles with the flow of blood in the vein, when the osmosis and the one-way movement of the valve is actually playing. So these are one of a few concepts, I think, which you need to know prior understanding the basic nature of cyber forensic. And because you are in the forensic, so I can have a hours of discussion on cyber law on different perspectives. But what I feel that my discussion should be in such a way that it should be fruitful, so that you can have some encouragement in the days to come. Look, I'm telling you, your future is very bright. Why I'm telling you? Because I'm coming from the real world, and in the real world, because I'm a self-made man, and I have started my journey since 2010 and 11. And when the people are not at all aware of what is cyber and how you're going to play a role in the days to come, since 2013, 14, in going to different seminars and taking the class in pan-India basis, I have all the time explained the fact that we are actually explain the fact that electronic evidence will going to play the crucial role in the days to come in every sphere of our life. So that is actually now happening, even after, especially in the wake of back-to-back 3 pandemic. We are those people who are actually not ready to accept the virtual world, reluctant to accept or adopt the virtual world. Now is also they are accepting, maybe forcefully, maybe they're bound to, and that's the reason the proliferations of electronic evidence of the virtual world in our day's real life is actually paved the way for a bright future for the cyber forensic experts personnel, and definitely other forensic field is also equally applicable. You know, every day our physics and, you know, different all my cases, not only cyber forensic, but apart from the cyber forensic, the other forensic, the medical forensics, the physics forensics, all are actually coming, the ballistic expertise, and everything is coming and are helping us to prove a particular fact. So you will going to have a very important role in the days to come. Already, you know that after 1980s, the DNA technology in USA has played a huge role, and there are a lot of interesting case studies along with a person was arrested and kept under custody. He was found guilty, and later on, when this DNA development came in, it was found that there was some hair. Piece of hair seized from the PO, and their DNA is not in any way matching with the accused person, and these are actually paving the way of a new forensic zone, and definitely cyber forensic is one of them. We have started our journey in the internet since 1995. Previously, computer was actually developing, or I should say, revolutionized or evolutionized, whatever way it is evolving and revolutionized in day to day. So we are actually heading for quantum computing, the latest of mine. And I'll share you that I have a YouTube channel. You can come to that YouTube channel, say ad free and free. And I have some important videos on that. I think some of them can be of great use to you. You can go and watch those videos. So I have discussed about one quantum, the important perspective of quantum computing, how the present not be very remote future, but it may be very near. We are nearing to accept the 0 Kelvin or absolute temperature processor, which is actually going to revolutionize the computing speed, at least. So these are days where we actually, and there are a lot of issues coming up for the cyber forensic experts, and definitely I think you will all heard about that, the cyber forensics instrument, the softwares, the things which is very available in India especially, are old enough to not to catch up with the development in the field of day-to-day development of in the field of different gadgets and softwares and other. And one of the most dangerous problems that for cyber forensic experts today worldwide facing is that of the increased use of the smartphone and its huge power, and this video and other PDF and other big files. Their forensic is actually posing a challenge. And another, definitely, you know, I think you all heard about another challenge has been posed by the Apple's application and its huge encryption power in messages and other things. So and obviously the forensic examination of SSD is also another challenge being posed to entire forensic community. So we are in the midst of difficulty, challenges, and challenge is a beautiful thing, because if there is no challenge, the people are not going to learn, everything will be stagnant. In the technological world, you cannot afford to be stagnant. You have to be mobile every time. You have to learn, you have to apply your learning, your knowledge, everything to in your practical job. So prior coming to our giving a simple discussions to all of you, that say for example one lady visiting a PS with an allegation that on her name a fake Facebook account has been created. So I'm going to mix both of the concept of the golden rule of the two golden rule of cyber forensic. We're going to get this within this example. The first thing that the lady will come and visit to the PO and submit the screenshot containing the URL, and these screenshot containing the URL. The investigating agency's first step will be to collect the URL. How the investigating agency will collect the URL? They can make a seizure of the screenshot which contains the header and URL and all this. So taking that URL, and you know what is uniform resource locator, is always locate a page on the virtual world. So after taking this URL and all, the next step is going to inspect the URL, and the domain name of the URL is actually showing that, say for example, Facebook account. My Facebook account is facebook.com/bivas.chatterjee.5. So within this URL, facebook.com is the domain. So we have to know that this domain name. We have then in the step number 2, we have to ask question to the domain of a company, providing a company, that may be Facebook, that may be anything. In our example, it is Facebook. So, because the lady made a complaint that on her name a fake Facebook account has been created on yesterday night at about maybe 8:30 in the evening. Our lesbia's pictures was uploaded. So the lady can give some URL screenshot containing the URL, and with the help of those screenshot containing the URL, the seizure can be made, and when the seizure has been made, those papers is coming within the ambit of the investigation. So that is one part. Again, after obtaining that, the investigating agency step number 2 will write a letter to the Facebook authority to provide the creation details and the login details. So creation details means, you all know that when a Facebook account is created, it can be created from a mobile number, it can be created through a email ID and all, and the third and the second thing is that login details. So in asking the login details, so you definitely going to have mention the date and time. So date and time, when it can be mentioned, it's going to give make the things easier for the investigating agency to handle. So in doing so, you can remember in your mind that with this example, I am going to show you how these two golden rule remains intact or followed or maintained within this investigation. So I think it will be of help to you. So in step number 2, the investigating agency will going to make a request under 91 CRPC and the Information Technology Act, Section 69, 69B, and the rule made there under. Recently, we have a IT Rule 2021, which is also playing a very important role. So I'm going to ask this question to provide creation details and the login details. So the person who made the post yesterday at about 8:30 through that fake account was actually logged into the Facebook account at 8:30 or prior to that, and then only he could have uploaded that post. So if you can know, because this is my mobile phone, and now this is my mobile phone, and the time I click on the mobile data, I am connected with the internet. So the time I'm connected with the internet, the interesting thing is that it can be a straitjacket formula, that the time I am connected with the internet, my internet service provider allocating me a IP address. So I think you all know what is IP address. Now this is this IP address is actually helping the concept to rebuild or revisited of the local exchange principle concept to be revisited in case of cybercrime investigation or cybercrime trial or this type of incidents. So every time a person is allocated with an IP address, and he always have a MAC ID with respect to his machine, and if the MAC is tagged with the IP, then wherever he is visiting, maybe I am connected with the internet, I'm going to the Facebook, I'm going to the Flipkart, I'm going to anything. So every time I'm entering into the Facebook account with my IP, the log of the Facebook will going to capture my IP with respect to date and time. So every step now is documented. Not only that, every time a criminal is doing crime, he is leaving some trace into the system. So you can understand how this local exchange principle going to be fully applied in today's modern parlance, modern forensic footprinting. So basically, when we are making request to the forensic expert, Facebook and other, then the Facebook will provide us with a reply, and you can put those reply to the IP lookup and other. We're going to get the internet service provider who have provided with this IP address, and that IP address, if we put it into, say for example, I think you all are aware of the fact, but still I'm just sharing my I want to share my so requesting you to
Yes, sir, it is allowed, sir.
Please allow me to share.
Yes, sir, you may share it, sir.
Prem Kumar, please cooperate.
Yes,
Now it is okay. Now it is okay. So I think you can see the browser here. So I am connected with the internet. So I'm writing what is my IP. So this is my IP. Now I got my IP. After obtaining this IP, I want to know what is my, or you may want to know what is my, who is the internet service provider who has provided this IP to me. So in order to do this, there are a lot of free softwares. So I can type on IP lookup, and going to the IP lookup, there are a lot of websites. You can open any one of them, and going to this, we can get a box everywhere. So we can put this IP, and it is always there, default IP is there. So after going to this, there will be a full-fledged result. And if you go by the result, we see this is the internet service provider of my internet connections. So this way we can know easily know that who is my internet service provider. So in step number 3, actually I have already discussed about the step number. I already told about the step number 1, that is a collection of URL. Then we've come to we're writing to, so by this time I think you all aware of what is URL. So you can go to the YouTube channel, and there you can go and write Vibhav Chatterjee. So if you open this Vibhav Chatterjee URL, so this is my URL. So this URL, you can take this into the so this is the URL. So within this URL, this is the domain. So this domain name, if anything required for information in step number 2, we're going to write to the YouTube, maybe that is Google Incorporation, so that they can provide. So in Facebook, it will be, I think in our case, it is Facebook. So we can write this in this way. So facebook.com maybe or anything. So this is the URL. If we inspect the URL, the domain name is actually from Facebook. So in step number 2, we're going to write a letter to the Facebook authority. The Facebook authority, that please provide us with the, which I already told you, provide us with the creation details. Sorry. And login details. Login details mean with respect to a date and time. That will make the things easier, because we're going to give the yesterday date and yesterday evening 8:30, because that was written in the complaint. So these are the requests, and after obtaining this in step number 3, definitely in step number 3, the in step number 3, the Facebook authority is going to provide with the IP address. So what are you going to do with this IP? We're going to put this IP, I already show you, to the IP lookup, and we're going to give the ISP, the name of the ISP. After obtaining the name of the ISP, our last step, is very simple now. Investigation is completed almost. We're going to ask the ISP whom you have allocated this IP address on that day, on that point of time. That is our case, because the person who is uploading, maintaining, and making post on the fake account is actually created the account maybe and uploaded the same on 8:30 yesterday. So from that perspective, we're going to ask to the ISP, that please provide us with the, so to the ISP, we're going to provide the table, and that table content are date, time, IP address. Now with respect to this table, we're going to ask the service ISP, please provide the IP DR log IP allocation details. So from these, they are going to provide an IPDR or IP log or IP allocation. They are going to have the connection number and all this. So from that, we can go to the house of the, because thereafter we're going to ask to the in the next step, in the step number 5, we're going to ask the ISP to provide the CAF, customer application form, because we already got in step number 4 the IPDR, the connection number and everything. From that number, we can ask for CAF, and from the customer application form, we can ask for, we can get the name, address, father's name, voter card, Aadhaar card, and everything. So from that, thereafter the investigating agency can make a raid into the house of the offender, and then start the hardware portion, because you see this part, every step has to be documented, has already been complied with. Now, I think you all are aware of the fact that now I'm sharing a PowerPoint. So basically, see what are the changes are coming up in different part of the world. recently German wing crashed, and in 2015, and it was seen that the co-pilot was using a tab, and in that tab actually he was searching for, it was found that he was, prior to the class, he was searching for ways how to commit suicide. So these actually help to understand or find out what are the reason of the clash on the Alps. So all the crew member and all the passengers was actually died. So that was the thing. Another interesting example is a woman wearing a Fitbit and was actually doing his her household chores on that day. And after these, all these, the husband alleged that he had he went for the office, went out for the office, and in the midway, he discovered that he was going without laptop, and he came back to the house and saw that his wife was mercilessly beaten by some person, and he tried to prevent and protect his wife, but he was also injured and became senseless, and he regained the sense or conscience, and he saw that his wife was lying dead on the floor. So he started filed a complaint, and investigation was started. And when the investigation was started, it was seen that the husband was not telling the right thing. Actually, the time he was telling was not actually matching with the data that the lady was live from 9:18 to 10 OM AM 10:05 AM in the morning, and she traveled on that 1,217 feet, because after all the persons left, might be she was actually doing some jogging, and that's the reason that such a huge traveling feet was actually recorded. The travel space was recorded, and she was still alive, and which is actually very much contradictory to the statement given by the husband. And later on, the husband was arrested on the basis of these contradictory statements and other evidences. So these electronic evidences, gadgets, forensically extracted data are actually very useful. See, in 2016, two police cops was actually having a heated debate in a hotel room, and thereafter one murder another, and the court issued warrant, search warrant to the Amazon.in to collect the voice recorded by the Alexa, which was there within that this room. So you understand that when the world will going to taken over by world will be took over by the 2.6 billion Internet of Things, what be your job requirement? So it's a staggering amount of job. So nevertheless, never be disheartened, because the problem in our country is to channelize the resources in the proper way, and that's why such a big brain drain is actually recorded since independence. But if there is proper plan, because in every investigations, in every trial, what I see is that we are heavily depending on the forensic expert report, and without this forensic expert report, nothing can be easily been proved, because other circumstantial evidence, other evidences, they are important one, but forensic expert report is as well very
Sir,
important.
sir, can you make it in full view mode?
Yeah,
Full
definitely,
screen, sir? Yes, sir.
definitely. So Gary McKinnon is one of the fantastic and phenomenal person. He was actually punished for his venture, and I've shared this Wikipedia link. You can go and read the entire episodes. Entered into the system, hacked the system, and ultimately diverge the fact that there were UFO and activity and other technologies potentially useful to the public. So this is there. So you all about aware of the dark wave and all these, and the most important thing nowadays, the crime is coming up, ransomware, and new challenges coming to the investigating agency. And the point actually which is actually you are more concerned about is the Mr. Paul L. Kirk's expression about the Locard exchange principle, and the beautifully adapted word. I always try to mention this thing. Wherever he steps, he means the suspect. Whatever he touches, whatever he leaves, even unconsciously, will serve as a silent witness against him. Not only his fingerprints or his footprints, but his hair, the fibers from his claws, the glass he breaks, the tool mark he leaves, the paint he scratches, the blood or semen he deposits or collects, all of this and more bear mute witness against him. This is evidence that does not forget. It is not confused by the excitement of the moment. It is not absent because human witnesses are. It is a factual evidence. It is factual evidence. Physical evidence cannot be wrong. It cannot perjure itself. It cannot be wholly absent. Only human failure to find it, study, and understand it can diminish its value. So you can understand that it is factual evidence. Physical evidence, it can never be wrong. It cannot perjure it itself. It cannot be wholly absent. Only human failure to find it, study, and understand it can diminish its value. So the value can only be diminished if this is because of our inability. So what I want to make all you, the forensic students who are actually listening today or attending today's uh, lecture, that this is the thing I want to harp upon you, that this inability which we have inherently requires to be cured. Otherwise, the result will be catastrophic for the society. Why I'm telling so? Because the real offender will roam scot-free because of the lack of evidences, and even the the justice seeker, the person who was the victim, will never get justice, and the court become and the honorable courts become helpless. So these are the reason I think you should take this subject very seriously. So Mr. Locard, forensic science basic concept, I already explained you, is equally valuable and applicable in case of cybercrime investigation or in case of a cyber forensic examinations. Because so the principle is something is that every contact leaves a trace and applies to the contact between the individuals as well as between individuals and a physical environment. So you can understand that every contact leaves a trace. So whenever we are in any websites or any sites or any page we are entering into virtually, our IP address with respect to date and time is actually been captured. So these are the forensic footprint, the digital forensic footprints, which is going to be available in the hard disk of the offender. In many of the hard disks or in mobile, when you send the query to the Central Science Forensic Laboratory, we ask for a lot of query words. So asking for informations depending on those query words and all this. So these are there, and definitely I just share it's an example, live example. In 2007, in 10 and 11, a lady filed, actually her father filed a complaint. The allegation was that when she returned to the Bengal, because she was pursuing her study at National University in India, in one of the part beyond Bengal. And when we reached to the Puja vacation, she was surfing internet and all of a sudden she encountered and was shocked to see that on her name a fake Facebook account was created and lascivious and other pictures were uploaded on that. So and those pictures were uploaded on that. And the lady fathers filed a complaint. CID investigation started investigation. It dates back 2010 and 11, and then on 2017 I have been appointed as a special PP to the case. When I entered as a special PP to the case, what I did is that the PW4 was going on, was a forensic expert who examined the hard disks of the forensic of the offender and extracted data and send it to the court. And I temporarily stopped that, pray for a temporarily halt of the investigate trial, and I pray under 91 CRPC to make a re-examination of the image copy. Whenever the first investigation was done, the first step of the investigation, the forensic science laboratory will going to make a forensic image of the same, and they will do their experiments on the forensic image and not on the original one. So they do the forensic experiment and all this on the image copy, and those image copy and everything will going to it was written in the laboratory. And I annexed some 5 pictures and send a query to the forensic department through the code, and the code allowed my prayer, and the prayer contains a request to the forensic science laboratory to re-examine the suspect hard disk data, image data, with respect to whether those 5 pictures were available in the hard disk of that device of the or computer or the CPU of the suspect. And believe me, when I first took up the case, it was a losing case for prosecution. When the result came in that out of 5, 4 pictures was found in the hard disk, and those 4 pictures directly connect with the allegation put forward by the lady, and that comes as a very important evidence. And this is one of the history in Indian judiciary, that the forensic experts report examination was a forensic. It was the forensic expert was re-examined, has re-examined the in his laboratory the entire thing, and it came before the court, and the face of the trial changed drastically. So this is one of the reason. So things are coming one by one, and in Section 790 of Information Technology Act. Actually, I'm not going to detail the nitty-gritties of every sections. They're going to make things boring for you. I'm coming to those perspective of cyber crime and cyber related things, which is actually you should know and be of your immense use. So electronic form of evidence has made it universal, and it means any information of probative value that is either stored or transmitted. The probative value means on which the court can depend and pass a decree or order. So that is either stored or transmitted in electronic form, and includes a computer evidence, digital audio, video, digital video, cell phones, digital fax machine, etc. So another very important and fantastic observation on cyber forensic is that of Frye versus United States. And you see, in India, we have Indian Evidence Act. Our equivalent Evidence Act in USA is that of the digital US's Forensic Act and all. And there's an article called 1013. So in this 1013 article, we get it is admissibility of scientific. When the question of admissibility of scientific evidence come, sorry, I was telling about the federal rule of evidence. The federal rule of evidence is actually equivalent to of the Indian Evidence Act, and federal rule of evidence article number 1013, the admissibility of scientific evidence. Expert opinion based on scientific technique is admissible only where the technique is generally accepted as reliable in the relevant scientific community. This is very important. So every forensic laboratory, whenever they are making the experiment and giving a report or result, they have to follow the standard SOP, which is actually accepted or relied upon by relevant scientific community. So that's the important thing, the Frye and United States observation. The Dobbin and Medlin Dow Pharma, Supreme Court ruled that the federal rule of evidence superseded Frye as the standard for admissibility of expert evidence in federal court. So in rule number 70, federal rule of evidence, it provides that if scientific technique, scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, and experience, training, or education may testify thereto in the form of an opinion or otherwise. So you can understand this important part. Another basic thing is that of to make you understand that of the very concept thing you all are aware of. Say, for example, these 3 lines was there in a file, in a folder, in a pen drive, And when the investigating standard countries investigating officers will collect the thing for first time, they're going to make a image of the same, and this image are going to create a hash value, which is now calling as digital fingerprints. And you see, I told you this is the evidence, which it is not the evidence which is important. It is how we collect, how we preserve, and how present review of the code is important. See, you'll understand why I said so. Is that in presence of equal L and the full stop, there is a space, and I have tampered with the evidence. And if I then make an image of the same, you see the entire digital fingerprints has been changed. So the first part of evidence will go, the first evidence will go to the code, and the next part will go to the dustbin, because the next part is a tampered, edited, and destroyed evidence. So that's the important thing. So electronic evidence informations are now in many forms. They can be audio, video, and any part. So Justice Baer has given a fantastic observation in Science in Courtroom. He said that in this age of science, science should expect to find a warm welcome, perhaps a permanent home in our courtrooms. Our decisions should reflect a proper scientific and technical understanding so that the law can respond to the need of the public. So that's the important thing. But there are important differences between the quest for truth in the courtroom and the quest for truth in the laboratory. Scientific conclusion, you should know this very much. This is an observation by international law and also adopted by in our by Supreme Court of India in our Supreme Court of India in AP Pollution Control Board versus Professor M.V. Naidu. So there are important differences between the quest for truth in the courtroom and the quest for truth in the laboratory. Scientific conclusions are subject to perpetual revision. Law, on the other hand, must resolve dispute finally and quickly. In state of Maharashtra versus Praful B. Desai, the Honorable Supreme Court has observed that the advancement in science and technology has also helped the process of law in administration of justice. So this is actually the pillar of all evidence or the forensic part of the evidences and all. The IT Act has defined computer as a machine or an optical device or a high-speed data processing device. This is important. And hash function, you already know, this is very basic of forensic examinations. It means an algorithm has been defined by our law or information.
Sir, excuse me, sir. Sir, are you moving the slide, sir?
Yes, brother.
Sir, it is now stuck on the previous slide only.
It may be because of my slides. My PowerPoint is huge in slides, number of slides. So it may be that's it making it very slow. Is it okay?
Yes, sir. Yes, sir.
Yes,
Yes, sir.
now it's okay. Now it's okay.
So I think previously this is I told you about Justice Baer's observations in Dow Pharmaceutical Incorporation's case, and then Praful Desai case. This has given us a guideline of how to deal with science in courtroom. Scientific because a forensic expert is doing nothing but the scientific experiment in the laboratory. So how these laboratory scientific findings will be taken care of by the judiciary, this has been given by different judgments different times. Some of them I have discussed here. So the hash function definition is very interesting for you. It means an algorithm mapping or translations of one sequence of bit into another, generally smaller set known as a hash result, such that an electronic record yields the same hash result every time the algorithm is executed with the same electronic record as its input, making it computationally infeasible to derive or construct the original electronic record from the hash result produced by the algorithm, and that the two electronic record can produce the same hash result using the algorithm. So these are actually helping a lot. Now we have Information Technology Act, and I think this will be a little bit of boring for you. So there are some provisions. Important thing I must come there are different type of cyber crimes. In the one of them is a cyber terrorism. It is defined under section 66F. The first part of the F is containing the definition, and the second part quantum of punishment, and the quantum of punishment is life imprisonment. You see how powerful a trick a hacker or a cracker can be. They can destroy the critical information infrastructure of a nation. So critical information infrastructure has been defined in section 70 of Information Technology Act. it is such an information that any incapacitation of the same is going to have a debilitating impact on the economy, on the law and order, in the on the health, and on the defense of the country. So this is critically speaking are very if a critical information infrastructure is hacked, our entire country is hacked. So from that perspective, if anybody, um, uh, whoever, with intent to threaten the unity and integrity security sovereignty of India, or to strike the terror in the people or in the section of the people by denying or cause denial of the access, there are so many ways attempting to penetrate, introducing or causing to introduce any computer contaminant, knowingly or intentionally penetrates or access the computer resources. If they are doing all these things, it can come under the definition of cyber terrorism. So there are a lot of examples of cyber terrorisms. It already happened many years. Child pornography and pornographic materials and all these are there. Cyber warfare, squitting and all, email bombing, and these are different type of crimes coming up. Crime on mobile phones are always important. So most of the mobile phone are infected by malware in today's world. There are mobile app. You are all heard about the sandboxing and jailbreaking technologies. So phishing is actually one of the prominent cyber crime mechanism where the normal innocent people's becoming the victim of social engineering by the fraudsters, and there are foreign laws, and it can be cybercrime can be against the property, it can be against the person, it can be against the nation. So the cyber laws in India, it can be Information Technology Act, it can be Information Technology Amendment Act, it can be rules under Information Technology Act, and there can be amendment in major acts. Say, for example, Criminal Procedure Code, Indian Penal Code, and Indian Evidence Act. So in CRPC, there are a lot of amendments coming up. In Evidence Act, I think all heard about 65A and 65B. For any person who is producing electronic records has to provide a statement under 65B. So there are a lot of changes in penal code as well. In place of documents, there are content called document under electronic record. So today, if there is a forgery, it can be electronic forgery. So in Information Technology Act, in the statements of objects and reasons, it was stated that new communication system and digital technology have made drastic changes in the way we live. A revolution is occurring in the way people transact business. So this revolution is important. So there are 14 chapters in the Information Technology Act. We have a lot of evidence. See, interesting. See, if you come to the definitions of Section 7 of Information Technology Act, retention of electronic records. How can electronic record be retained as per the Information Technology Act? Where any law provides that the documents, records, or information shall be retained for any specific period, then that requirement shall be deemed to have been satisfied if such documents, records, or information are retained in electronic form, if the information contained therein remains accessible so as to be usable for a subsequent reference. So this is a big thing. Why I'm telling this is big thing? I think you all heard about that concept called the digital dark age. Have you ever thought that a manuscript, an inscription on the wall, maybe 2000 years old, history, as the says, and now living in today's 2022 generation, if you want to know what is wrote down there, it may be in Sanskrit, it may be in Pali, it may be other languages. We can translate the same and you can read. Till today, you can read. Our Upanishad, our Ved, and everything was dates back, age old. You can still read it. But think about 20 years previously, our data was in a floppy disk. It may not be read. It may not be read in today's perspective. So, so this is the reason. This is the thing. Actually, we should be careful about, and that is why new technology is coming up, so that today's PDF can be read even 100 years after this date. So this is one of the reason which is actually causing a headache to the technologists, how to handle this digital dark age. Then comes the concept of the electronic record is written in the format in which it was originally generated. This is a very bogus concept. Law laid down in Parliament. I don't know how can this can come to retaining a format in format in which it was originally generated. I think it's impossible. Say, for example, you are using a Windows 10 or 11. Every now and then you got a updation or upgradations in your system. The OS is managing the resources of your computer or hard disk. So how can you say that everything is written in the format which is it was originally generated, sent or received? I think this is a bogus concept. I don't know technologically, strictly how can it be possible. The details which will facilitate the identification of the origin, destinations, date and time of dispatch or receipt of such electronic record are available in the electronic record. So provided that this clause does not apply to any information which is automatically generated solely for the purpose of enabling an electronic record to be dispatched or received. So for this case, it's not been applicable. So these are actually some of the definitions. I think I don't want to go in detail of the nitty-gritties of the things. But most of the evidences in the virtual world, there's a huge amount of evidences in the virtual world actually of pornographic one. So there are some provisions, which is penal provisions. Somebody can tamper the computer source code. That's an offense. And the hacking, we have the criminal law section 66 and this and of the IT Act and section 43 is actually the civil part. So if anyone is accessing or entering into any device without any permissions, without anybody's permission, dishonestly or fraudulently, then it's a hacking. So 66B punishment for dishonestly receiving stolen computer resources or communication device. 66C punishment for identity theft. So if you got my password and entered into my Gmail account, then it's a offense committed by you. Punishment for cheating by personations by using computer resources. Punishment for violating privacy. Punishment for cyber terrorism. Now, publishing or transmitting obscene material in electronic form, that is 67. And 67 is actually further bifurcated into two aggravated provisions, 67A and 67B. In both of them, the subject matter is that sexually explicit material, transmitting and publishing sexually explicit material or material containing sexually explicit act. And the difference is that 67A contains of the picture is of a old one, adult one, and 67B is of a minor. So there are different digital signature related offense, and those are actually there. So these are different things. I think it will be boring for you to discuss. Now come to finally very interesting case studies. Actually, I am in most of the cases, I am actually standing on behalf of the state as a prosecution lawyer. But this is one of the case where I have stood as a defense lawyer. One person visited my chamber with an allegation that that he was arrested and he was arrested and he was actually he was arrested and he was behind the bar for 62 days, and he visited my chamber with a fact that on that day the allegation was that he has sent lascivious content mails or through messengers, Facebook Messenger, lascivious material and remarks to our lady judge because the person was a bench clerk of a court and alleged to have sent lascivious comment to her, and the lady filed a complaint, and on the basis of that, investigation was started. The mistake the investigating agency made was that in the material which is actually in the formal FIR portion, in the column, the name of the offender, he has written, the investigating office agency has written that the name of the person in whose name the Facebook account was created. It was actually grossly mistaken because it would have been the user of the URL of that Facebook account. So anyway, he was arrested on the strength of that, and then he was behind the bar. And when he came to my chamber, alleged that on that very day he had made no Facebook. He said never entered into the Facebook. Sending any comment and other things was actually beyond possibilities. So what I did on that day, I take a permission from that person, opened his Facebook account using my internet connections and my computer as a defense lawyer on his basis. And what I did, I'm showing it from my Facebook account, so you can know, that there are in my login homepage, there is one triangular button, and on clicking on that triangular button, there will be many active drop down box, and within that there was a column called settings. So you can click on the setting, and in the general account setting we have a page, and you can see that my Facebook account was created from bibas.gmail.com email, and download a copy you can click, and clicking on the download a copy, you can download a entire copy of um, the data within this, and clicking on the download a copy, another page will open, and the Facebook will going to say that, okay, we are going to make an archive of yours, and that archive will contain all the posts, all the photos, all the videos shared, and messages, info, and everything. So you can click on the start my archive button, and that start my archive will going to open another page, and they are just, Facebook is telling that we are gathering your photos, wall posts, messages, and all, and ask for some time and sending to my account. So I told you that I have been registered with my Gmail account, bibas.chatterjee@gmail.com. So they are opening, making a archive, and then there are notification coming up that they are gathering informations, and will send an email to the bibas.chatterjee@gmail.com when it is ready for download. So when I click on the OK, after a few minutes, I got a mail from the Facebook authority, and within this mail there is an URL, and I click this URL, I got the one archive PDF, and believe me, that has solved the case that the man was telling the truth, because going analyzing those PDF data, I saw that for every time somebody logging into the Facebook, there are four type of data coming up. One is the time and date, another is the IP address, another is the cookies details, and IP address I obtain it from this IP archive, but those IP I put into IP lookup, I saw that there's a Bharti Airtel connection, and the man was not using any connection from Bharti Airtel. So that is one of the finder. And another very interesting thing is the last part, that is a browser details. The browser details says that on that very day, his Facebook account, suspect Facebook account, was accessed from a Samsung 1033 model mobile, but the person was actually using a Nokia, and during the investigation, police has seized his Nokia mobile. So this was the reason I got some truth. I found some truth in his statement, and then I put all these things, and then I send it to different. I put up download all the document along with the statement of 65B. I have submitted the same, and then there was a further investigation, and later on this case has resulted into FRT, and thereafter again there was another investigation that has resulted into, and this is one of the important case actually. So you are free to discuss with me, and this is my number, and you can come to my Gmail account as well whenever, and I'm also in the Twitter @Cyber Chatterjee. So you are always welcome. So now I open the floor. You can have any question, whatever coming up in your mind, and I'll discuss and request you. You can also go to my in the last pandemic, I have come with some mobile application, and you can go to the Android. I couldn't get the time to have a Flutter version to get it more in Apple and Android. It is only available in Android, and you can go and download my application if you want. And I have completely translated the Information Technology Act, our only cyber law, into Bengali, that is our mother tongue, and made a mobile app which has actually been available in government website, as well as go to the Play Store, you can install that. And there are some other thing. Another important mobile application which can be used to you is that of electronic record, electronic evidence. This app is also been made by me. So you can contact with me. So there are so many participants I saw that I see that this day. Thank you everyone to giving me a patient hearing, and you are requested. If you have any question to ask me, feel free. If I can, maybe able to answer you. So you can.
Sir, we have questions in the question answer section, sir.
Okay.
So you can see there is Q&A.
So
Beside the sharing of
Sayantan Das said, can an electronic documents be confidential? Can an electronic record documents be confidential and authenticable? Why? Yes, definitely. The 5 important ingredient or characteristics of an evidence or an electronic evidence or document is that of relevancy, admissibility, completeness, authentic, and believable. So among them, the two most important is that of relevancy and admissibility. That's why I discussed about 1665B. So definitely electronic records can be confidential, and it can be dealt with in confidentiality. And definitely for authenticity, you all aware of that. That's the reason you forensic students, when you go take your career in cyber forensic, you'll be much in need, because this authentication is been made by forensic instrument or forensic softwares. Heard about some the name, there is MD5 and SA and all this. So these are coming one by one. These are coming up. Then can WhatsApp chat be used as an evidence? Look, there are two ways of interpreting this question. Recently, the Honorable Court has said that we cannot rely only on WhatsApp chat. In one of the case, in a civil suit, there was a telecom infrastructure company tried to execute a civil case, telling that from the opposite person, they owe 7 crore rupees, and the person admitted that he was entitled to pay 7 crores because there was a WhatsApp chat which wherein he accepted his liability and all this. So the Honorable Court says, okay, we cannot rely on this WhatsApp only because it can be tampered, it can be doctored and anything. So in that way, it cannot be reliable. But there cannot be any straitjacket formula that we cannot or should not rely, because if the other evidences are ample, and this WhatsApp chat is only of having corroborative characteristics, then definitely this is an evidence. So it'll definitely, and after this IT rule 2021, we have come with that those end-to-end encrypted groups, say for example, chat messaging company, say for example WhatsApp, they are going to provide the identity of the originator, the first originator. Say for example, you opt in a WhatsApp chat, and that is very much lascivious and contrary to law. So the first time it was shared, the first originator, it can be traced out. Then definitely his IP address and other things will come up. But one tab was the restriction was that there is no one have the authority to give the internal data or the chat details of that discussion. So now come to another question, that what happens if there is a conflict between an internet domain and an existing trademark? What happens if there is a conflict between an internet domain name and the, definitely we have different kind of cybercrime to that, cyber squatting and all. So I think you all heard about the McDowell case. A person booked a domain on that name, and it's a very famous company. And there was a fight going on, and ultimately the McDowell had to purchase that domain, spending huge amount of money. Recently, it happened with me. I was actually using cyberchatterjee.com, and that was my purchase domain. And I was busy with some of my criminal cases. That time was horrific busy. Still today I am, but GoDaddy has sent me notification that you can renew that same, and I forget to do that. And when I got time, I tried to purchase that domain for 1 year. I saw that somebody else has already purchased, and some broker has already purchased, and trying to bargain me with a huge amount. So this has actually happened, and that shows that you're becoming famous. So I don't care. I'll be doing it on the other way, but this can happen. There's a huge conflict with the internet domain name, and then the concept is it can be interpreted in two ways. Say, for example, somebody is purchasing a domain name, say cyber.chatterjee@gmail.com. Now I have purchased this, and the people knows that this is the domain of that person. So it was created by me. Now question is whether it is my intellectual property or not, and whether he has purchased it, that is why his own property. Now this conflict between intellectual property and normal rental property, this is a point of debate. So I don't know how can this point debate be solved, and if I get any case studies, I'll be discussed on the future days. Till date I have not that, because there's now a balancing attitude between these two. Pranay was telling that nowadays we can see in social media site that if you share and like the photo, the person will get 1 rupees from the Facebook, Twitter, etc., and they are really get payment. So this sharing and actually giving a that happen also when you if you know the concept of Google AdSense. So this is there, the people are earning, and unless and until it's contravenes or infringe any provision of law, it's okay. We're gonna infringe or do anything contrary to law, then the things will be arrested, or things will be taken care of. But if it is a spam, then it will be taken seriously care of, because in India spam is of not that big thing. We have only Tata Sons case wherein the even up to 100 SMS been allowed to be sent. But in developed, some of the developed countries, spam has been taken as a very serious one. I just give you a simple example. I remember with respect to this spam and other. In US, there is a very important, very famous marketing company, and its duty is to collect the data, our likes, dislike, what are we doing in the virtual world and everything. And after obtaining all this data, they are actually making our forensic image, forensic identity, and those forensic identities have actually then been explored for their commercial purposes. So one 17 years old minor girl in USA was continuously getting different spam messages containing, the content of those messages was that of material or advertisement on materials which has been used by newborn baby. So the girl was not married, and repeatedly the lady was getting this. Her parents filed a suit against this marketing company, and it went up to the court. And you'll be shocked and surprised to know that when the minor girl was medically treated, it was found that she was carrying 1 month baby, and she has conceived. How parents were not aware of the fact that her minor daughter carrying a first stage of pregnancy, or in the first stage of pregnancy, but the analytics knew the matter. It's the beauty, I think you all are aware of the artificial intelligence, the analytics, and the big data. They combined, they're taking data, big data, they're segregating into two parts, I think you all are aware of. They're one part of data, they're making a project, a map, things, and on those project and map and things, they are actually verifying the other data and telling that, okay, this is cat, this is rat, this is dog. Because machine doesn't know what is rat and what is cat or the dog. So we are making model. One model is based on the data, and another piece of our set of data is kept for to verify the accuracy of the model. So this is the basic of, I think, of this artificial intelligence concept. Because actually I am also a certified AI professional from Microsoft, so we have been taught with these things. And we had a very interesting project, which is the USA Law Enforcement Agency is going on. It's very contradictory and controversial project where it was forecasted. It was expected to forecast that whether the black skinned people have more propensity to commit crime compared to their white counterpart. So this is a very derogatory, this is discriminatory on the part of this. Is very much criticized this AI, and the China has gone miles extra. If you go to the newspaper recently, you heard about that the China has come with a artificial intelligent public prosecutor. So they are now having public prosecution with the help of this. Anyway, the next question is what if one fake Facebook ID has been logged in from multiple devices? So if it's from multiple devices, every multiple devices owner or the user of those accounts can come under the scanner of the or can be a suspect, because they are involved in it. But logging into is not going to be crime. But how come they are getting those password and other attributes by which they are entering into? That will be a concept. That will be a question which they have to explain when the prosecution will start. Sir, can it be? Where is the question? So can it cause DOS attack? Definitely. Denial of service attack is now a rampant one. And say, for example, if your device is made botnet and attacked, and then definitely crime can come. But in that case, whoever is making your device, it may be you are telling about DOS, I am telling about DDoS, distributed denial of service, is more horrific and dangerous in shape. So in that case, definitely the person who is actually making you target on that will come and actually ultimately be offender. So in the days to come, a lot of things going to happen. Rachana, I am Rachana Saha. I have question. Nowadays, I can find that there are certain apps through which one can put a male face on a female face, or a vice versa in a video or a picture, which is actually illegal. Then why can't we stop those who are making such app? Archana, wait for a few months or years. I don't know when it will come. I'm a strong advocate advocating the law of privacy. We already have the world's biggest law or legislation that is called GDPR. I have worked a lot to inculcate the concept of GDPR in our corporate worlds. I myself wrote to the government of West Bengal. They have allowed my proposal, and I conducted a 2-hour session on the GDPR to all the heads of our IT companies. And if you get time, you go to the Center for Excellence IT Department's website. You're going to get the entire video of 2 hours of mine lectures will be there on that point of GDPR. And we are expecting the similar law in India. Our data privacy bill is there. It was there in the winter session, but I don't know why it was not passed. And if it has been passed, then definitely this face is actually our personally identifiable informations, and it has been inculcated into the 3rd biometric informations in the Aadhaar. So I think it's an important thing. So up to what I'm there? Hello?
Sir?
Yes, sir. Yes, sir.
So any one of yours can read the questions one by one?
Sir, Sujay, sir.
Please do the needful.
Yes. So, sir, the next student asks, Sir Yasir Ali, with the reference of 65B admissibility.
No. There was Sayantan Das, man in the middle attack.
Shayanton Das. Yes. Man in the middle attack required for electronic evidence or not? He's asking.
Definitely, the traces found in the man in the middle attack all are electronic evidence to frame charge or prosecute him properly. So to make up the evidence, the chain of evidences, definitely it will of use. Next, yes, sir, Ali.
So the next is, sir, student asking about in reference to the 65B admissibility of electronic evidence of IEA 1872. Can you please tell regarding the admissibility of WhatsApp chats in the court of law?
Definitely, I already discussed about the WhatsApp chat. Honorable Court, Supreme Court has come with an observation recently against the reliance of 60 WhatsApp chat. But if the 60 WhatsApp chat is to be taken, it has to be made admissible. And in order to make it admissible, we need 65B statement. Who is going to give this 65B statement? The person from whose device this WhatsApp chat is coming up. So if you want to know what is the format of 65B, you go to the Google and type with the format of 65B. You get my my own blog post under the Show Legal. That is the one nearly say 80,000 people have already visited. I have shared 3 format of how to write 65B, so that a common man can write a 65B, because it is ultimately the common people from whom the judiciary is expecting that they will come with electronic evidence within 65B. So you can go and read those things. Next.
So the next question is, if a perpetrator uses VPN and they want to know about VPN and all. Debarju Ghosh.
So the problem with the VPN, Debarju, is that I discussed about the traceability path in the first part of my lecture, that obtaining URL from URL to details of the IPs, and from IP to the IP ISP through the IP lookup and all this, then from ISP to the actual details of the users. All these are actually evidences. And but when the VPN is used, then this entire traceability path procedure may not work, because on that case the IPs are actually not the proper things. So in that case, in one side, using the VPN, we are enjoying the privacy. Our data have been encrypted. Our network channel data have been encrypted. But on the other hand, when the investigation peripheral will come, a crime being committed, in that case, the other side of the coin will have huge issue. Next.
So the next question is, if these people are reporting a profile in Facebook or Instagram, a fake profile, for the multiple time, then also it is not blocked. What should we do for further in this case? Asks Anjali Kumari.
Anjali, for blocking, we have a specific act law provisions under Information Technology Act, that is Section 69A of Information Technology Act. But thereunder we have rules, and for Anjali, for any person on whom a lascivious content, picture, mock picture, or whatever been uploaded in any significant social media, say for example Facebook, Twitter, and all this, then under Information Technology Act 2021, you can directly write to those agencies to block the page, to read the page, and within 48 hours from the receipt of the request, they are bound to do it. And if they are not doing, they're going to face punishment, penal punishment. And again, you can file a complaint before the law enforcement agency. The law enforcement agency again can send a request to the that concerned intermediaries, and that intermediary is going to treat the same. Next.
The next question is by Bidisha Chakraborty. She asks, can we know how many times the hash value has been changed from the evidence? How many times altered?
How many times hash value is changed means?
Every
time you are tampering the data, your hash value is changed once. Say for example, I have collected an original device. What does original? Nothing is original from a perspective. I am a coder. I know nothing is original. When I'm writing a program in any language, say for example, my favorite language is Python. I can write the biggest, one of the most famous languages, JavaScript, and in fact, I can write it on any language I want. I prefer. So I am writing the language, the programming, or giving writing a syntax, giving instruction to the compiler interpreter that on English. Oh, that's called higher level language. The machine doesn't understand that higher level language syntax. The machine only understands 0 and 1. So in that case, whenever nothing is original from the perspective. But see, for example, this is my mobile phone. I am crossing a road and I'm picking up this mobile phone and I'm capturing the video. And the video was first time captured in my mobile phone. So as per the Honorable Supreme Court latest judgment, Arjun Pandit Rao judgment, it is actually first time captured can be taken as an original evidence or primary evidence. So if we tamper with that without making a forensic image of the same, the first time we make a forensic image, what the Central Forensic Science Laboratory is doing, the engineer, the experts are doing, they are making a forensic image of the same, and then they're doing an experiment on the image copy. So the first time, whenever we are getting, an image value is created. Now, if we do anything with the original, say, I already explained 3 terms, which is the crux of every cyber forensic experts. That is accessed, modified, and the creation. If 3 are not changed, then I think the hash value should not be changed. And if that been so, then the integrity of the evidence remains intact.
Yes, sir. So the next person, Anirban Dey, says, thank you, sir, for amazing session. And he wanted to know about how to make the social media accounts much more secure.
Look, social media can be secured by 2 ways. By way of due diligence to be followed by the social media companies itself, which is beyond your capacity. And what is your capacity is to be aware before sharing. But there is a word called sharing. There's a phrase called the sharing with caring. So if you share with care, you will not, I think you will not expect it to get any in trouble in the days to come. And if in spite of that you are getting trouble, definitely go and file a complaint, because 98% cyber crimes, it is reported that it is stated that 98% cyber crimes are not actually reported, and only 2% is being reported. So you should report. I have seen in a lot of instances where people dare to report. There are a lot of victims of blockchain and Bitcoin nowadays in India, and these peoples are not actually, they have been cheated and looted, and they are not coming. They are fearing of being troubled in different legal problems. So I'll tell everyone to this program, please be courageous to come and file a complaint. Next.
Next, sir, Rahul Sinha, what are your opinion on trackers like Google Analytics?
I already explained about a very famous marketing company experiment, example. So definitely there are examples, there are instances that, and that's why there is a big clash between DuckDuckGo and the Google. Somebody is capturing the data from the browser. Your browser using data, and somebody is not. So definitely people who want to be more secure, they can use the DuckDuckGo and these type of things.
Sir, the next question by Bikram Das, what is the penalty for hacking with computer systems in India?
3 years and up to 4 lakh rupees fine, and sorry, 1 lakh rupees fine, and in case of section 43, there is a civil part. The damages they have been affected with, you have to compensate. So that's also there is a civil part. There's another forum, except the police PS or in the police thana or another, we have another adjudication forum that is called the cyber adjudicator. You heard about a lot of cases I have fought on behalf of the different peoples, and in Bengal I am trying to make the forum very popular. Recently there was a 20 lakh rupees dispute was solved. A person's bank account in 4 transactions at the 5 lakh, 20 lakh has been siphoned from, and he actually was roaming about from pillar to pillar, and from since 2015, and ultimately filed a case in 2021 before the cyber adjudicator, and the cyber adjudicator found the bank having a latches in their cyber security system, and they were told to waive the loan and do the needful, and compensate the person.
Sir, one more last question. Okay, he removed the question. Debarjo Ghosh, many government websites have HTTP rather than HTTPS. Why is it? Why is this there?
Very bad luck. Bad luck, should I say? I don't know. I'm not going to remark, but I don't know. Purchasing a SSL certificate is not that of a high cost. So I think they should, because they're going to help us to have an encrypted system. And they're going to face the trouble in the days to come, because this is one of the reason of one ransom attack. Anybody?
Okay, sir. Sir, Raima Shah asked, how many dark web come up in the public domain, and how will it harm the public?
I cannot say, because after this Silk Route case, Rosso was arrested and was given a huge punishment. I heard that a lot of there, but I'm not going to speak publicly on this forum, because many a time I thought of making a video or presentations on this dark web, but I restrained myself from doing so. In order to calculate how much corrosive, dangerous websites are there, which can be accessed through the Tor or this dark web browser, and how much websites are there who are selling the narcotic drugs, the arms, the concept of killing the people. If I have been at all aware of, I would have not discussed it in an open forum today. Sorry.
So can we go to the next question?
Please.
So, sir, recently the fingerprint cloning, biometric cloning has been done by the culprit. Police had arrested the person who had committed it. How can we protect us from that? Pritha Kundu asked this.
I think, Pritha, this is one of my case. I have been the prosecutor into it, and this is a huge problem. When the Aadhaar came in and was attempted to make a compulsion, I raised the first voice from my end, telling that hacking Aadhaar will going to hack a person, and if the biometric been tampered with or cloned with, then I have a very famous case at Bakura, where two people used their biometric to register and made 40 forged bank account, and thereafter cheated and looted the people. So these bank account, these biometric informations of the common people will going to play havoc, because on that case the real offender will smile, and the offender will going to be and the real offender will smile, and the so-called offender will be victimized, an innocent person. It's dangerous for the society. Even the terrorists can use those things.
Sir, Arnab Chandra asked that is there any special power is there by the investigating agency so that they can mail up to Facebook and they can ask for the offender's details?
Is there any?
Is there any special important right or power by the investigating agency?
Look, interesting question. Unlike the USA, in USA there we have a Wet Trap Act. So anybody wants to enter, say, law enforcement agency especially, wants to enter take entry into the suspect device, say laptop and computer, and collect the data, they need to take a search warrant from the court under those acts. And there are concept of ethical hacker in US and other part, and in law has sometimes supported the things. But in India, till date, we have criminal procedure codes which provides the process of investigation. And some of the tricky part, actually specialized part, has been dealt with by the Information Technology Act. And reading all together, what I understood is that in India, if there is a cognizable case, investigation is made out. In that case, offenses were having more than 2 years imprisonment and all this. So in that case, if the cognizable case is made out, investigation is being done in a cognizable case. In that case, the investigating agency has a huge power to enter into and collect the data. And that for same reason, Section 78 of Information Technology Act is giving a huge power, stating that if there is news that or apprehension that a crime under IT Act has already been committed, is about to be committed, and already committed, about to be committed, and is being committed. In that case, the inspector rank officer can straightway enter into the system PO and search, arrest, and do the etc. So that's the law we have.
Sir, we are done with the questions. Students are again and again putting questions. We
Hey,
are
this
curious
question I'll be taking up. This is very important question. Why the ethical hacker? The concept now telling this is very important question. Just give you one point. We have a huge misconception. Just to tell you and make this point clear, there are organizations of the people who are telling themselves, boasting themselves to be the ethical hacker. This is absolutely bogus, and these are the fraud people. I'm repeating, these are the fraud people. Why I'm telling so? I'm very vocal against these people from the beginning, and not me. One of the top IT planning personnel in India. I don't may name the mention the name of that person. He's the framer of different rules and laws. He and me we have the same mind setup. This is the havoc business going on in the name of training the persons, taking the huge money to train them in the name of making them ethical hacker. I challenge those people on the point that no person in India should boast himself to be an ethical hacker. Only the police and the court has the authority to enter into the device and collect the data. That's the ethical hacking. Ethically hacking or lawful hacking. Otherwise, everything is cracking. So what is happening? The students, they are entering into different law colleges, MCA, maybe in your organizations, the people who are actually listening to me, there are people who has been already befooled by investing huge amount of money to these these huge organizations coming up, and they are being trained by these organizations. I don't want to tell anything against anyone, but my humble request to you all: don't spend money, your hard-earned money, your father's parents' hard-earned money, to these people. The organizations who are hosting today, they are the authorized organizations. Go and read their materials and excel in your professional activities. You can have thousands of materials to learn, but you don't go to be an ethical hacker. The time you become an expert and been absorbed by the forensic science laboratory or any laboratory, nowadays there are regional laboratories, there are thousands of laboratories, there are private laboratory concept and all this, but I don't think the private laboratory is at all, because if you go by 293, 294 of criminal procedure code, you'll get a list of the heads who are at all entitled. So my humble request to you too, that the only police and investigating lawfully as per the CRPC, and the court exercising its inquiry or trial can ethically enter into a system, or order to enter into a system. So when a mobile phone has been seized by an investigating officer and sent it to the forensic science laboratory, it is actually sent through the court endorse and give permission that it to be sent to the court forensic science laboratory. And then what the forensic science laboratory is doing, they are collecting the data, they are accessing into others' hard disk, maybe accused. He is not proved, because Indian law says until it is proved, no accused is actually the offender. So his or her hard disk has been accessed. It may be witnesses' hard disk been accessed, and they are taking access. And this is not unauthorized access. This is authorized access. Who authorizes? The court authorizes. This is an ethical hacking. But except this, everything is bogus.
Any more question?
I think people are there who actually participate.
So one more question is there. Does government use dark web for catching or tracking the criminals? By Shreyan Pal Chaudhary.
I don't know. I heard different from different sources. There's one of the USA agency who funded the dark web, but I don't get any. There's no evidence to that effect. It was originated. Dark web was originated by one US agency to include all the people in the world within this periphery, but it has become now the greatest enemy to the USA security agencies, because anybody go to the dark web, what will the NSA going to do? Their normal practice is they're going to block the IP or blacklist the IP. So I think you all know that you should know this. So whenever you are in the dark web, prior going to the dark web, please use at least Parrot. It's a very lightweight ethical hacking OS. If you cannot configure the Kali Linux, it's also lightweight. But I'm not expecting that you're going to use a Black Arc. Is the world's biggest and a voluminous channel or OS containing everything. So package you can call. So at least you go to the Parrot like light OS, and then definitely you activate your anonymous option, and then you go to and enter into the dark web. To me, that is the best thing. So I told more technical than the law, na? Sorry for that, but what can I do?
No, sir, it's okay. And we are, Prem Kumar, please stop taking the question from the participants now. So I am thankful to Advocate Bibhas Chatterjee, sir, as he comes down in a short notice period and delivers such an amazing lecture. Even if we also learn a lot, we don't know so many things. We also, this is nurture our talent too, with such eminent lectures from Professor Bibhas Chatterjee, Advocate Bibhas Chatterjee. And I may just give a very big thanks to Bibhas Chatterjee sir for such a eminent speech. And I may request to Miss Ushmita Pal, Professor Ushmita Pal, to just giving vote of thanks and then for ending the session.
Yes, sir. I would like to present a huge amount of gratitude for Bibhas Chatterjee sir for giving this speech, for giving us time out of his busy schedule, and enriching us with such a vast amount of knowledge that we have gained today from his very detailed and minute speech that he has given us. And with this knowledge and gratitude, we would like to conclude this session. I would thank all the participants who have come forward and asked their questions, for making it interactive session, and would also like to thank Gaurav sir for conducting this seminar, webinar in present times, what we call. So yes, with these few words, I would like to conclude this webinar for today. Thank you all.
One more addition to the participants. Participants, you can go and read about Sir Bibhas Chatterjee sir. His portals are there, open for you all. And also, sir has written a cyber crime manual, which is on electronic evidence, cyber security and the law, cyber contract, a legal analysis, dense cloud, legal analysis of cloud, information technology manual. These things are there. You can go and study. This is for all the participants. That's it. Sujoy sir, would you like to enlighten us and conclude the session?
Participants, actually today, Advocate Bibhas Chatterjee is here. He is not a simple and ordinary person. He is one of the celebrity in the legal world. Okay. He appointed as the special public prosecutor. So, and I know him personally from such a long time through his name. Okay. And he is one of the legend in the cyber laws. and also the IT crimes and all cyber crime world. So I may request you all to download the apps through Play Store, Google Play Store, or some other websites of the government websites. And you can easily find out him through the social networking sites also. If you have any required discussion with him, you can get in touch with him through his app or through his contact address mentioned in his website also. So I may give him thanks to Advocate Vibhas Chatterjee for his eminent presence over here, and I may